There we go. Good morning, everyone. My name is Judge Anthony Powell. I'm a member of the Kansas Court of Appeals, and we have one more case for our oral argument this morning. With me are Judge Henry Green and Judge Melissa Standridge, and we have a criminal case we're going to hear. I'll call the case of State of Kansas versus Anthony Ray Moss, case number 122775, and could the court have the appearances, please?
Good morning, Your Honors. David Loudon, Deputy Riley County Attorney. On behalf of the state, I would note that I was on the reply brief, but Kelly Cunningham was on our original brief, and she no longer works here.
Okay.
I would ask for 3 minutes for rebuttal, Judge.
Dave, could you give me your bar number again, please?
Yes, 15525.
Thank you very much. All right.
Good morning, Your Honors. Jeff Adam of the Robinson firm in Manhattan, Kansas, on behalf of Anthony Moss.
Very good. Thank you very much, counsel. And we've read your briefs, obviously, and we're acquainted with the case. So, Mr. Loudon, you may proceed, and you have 12 minutes.
Thank you, Judge. The essence of this case, as you know, it's an interlocutory appeal from the suppression of evidence, and the state is seeking to have that decision suppression reversed in this case. The primary reasoning for the reversal in this case was that the district court judge felt as if the reason for the stop had dissipated once the officer walked to the rear of the car and could see the tag and read the information from a short distance at the corner of the rear of the car. The state takes issue with that based upon the language of the statute and the case law. In particular, 8-133, as the state argued below, is a statute that not only discusses that a tag should be displayed, but that tag should be maintained free from foreign materials and in the condition to be clearly legible. In this case, the testimony from the officers was that the tag was not free from foreign materials or in a condition to be clearly legible. One part of that was I think they assumed that it had gotten wet, because when paper gets wet, it wrinkles up. One officer had described it as shriveled bacon, and it was wavy, so he could not see it from a distance of 15 feet. That was supported by the second officer who came in on this case and followed from a car length and still could not read the tag number, the date that it was issued, or from where it was issued. So it wasn't until he walked up and saw that that he could verify that the temporary tag was good. The difficulty
Mr. Loudon, was the picture of the plate introduced into evidence at the trial court level?
No, Judge. My understanding was that it was not. Okay.
Was there a picture of it?
That was the testimony, I believe, from the officers, that it was photographed.
Okay.
The problem with this case, however, is this wasn't the officers didn't say we stopped this car because the registration wasn't good, and that's a completely different section of the statute that talks about whether or when somebody operates a vehicle that they're supposed to have a registered tag. The issue wasn't whether it was registered. The issue was the condition that it was in, and that never dissipated. That piece of paper didn't become unshriveled, and until it was stopped, the officer could not read it. That was just part and parcel of the whole situation that caused it. As you know from our briefs, our argument is in line with the Lyons case from the 10th Circuit, where a police officer or trooper stopped a vehicle whose tag was partially obscured by dirt. And until the officer walked up to the vehicle, wiped that dirt off, he could not read every component of that tag. That is to be distinguished from the McSwain and Edgerton cases, where a tag was located, I believe, in the rear window of each vehicle, and obstructed because in one case, I think the officer said it was dark outside, but there was nothing physically wrong with the tag. And then the other case, the officer walked up to it and could see it, and there was nothing physically wrong with the tag. And that was the distinction that was made by the court in Lyons, to say that an officer's inability to read a tag, if it's due to some external condition as opposed to something within the defendant's control, then that was a distinguishing factor between those cases. So the Lyons court even said, look, it's not about disclosing that the tag is a proper tag. It's all about how it's displayed and what factors go into determining that. As it happened in this case, as the court's well aware, there was another violation that the officers were alleging to do with the tail light, or the tag light, I should say. It was hanging down and it was partially obscuring that. And I think that goes to some of that foreign material, and that possibly could be a stretch more, but it goes to the fact that they couldn't identify it from behind when they needed to. But in 8-1706C, that statute talks about the tail lamp, and it talks about, and I think that's there in that statute. That's where they get that language, because there was some dispute, I guess, at trial about any specific length or distance that the officer had to be to view it. And that's where the 50 feet comes from. And as I noted in my reply brief, part of the problem in this case occurred when the court at first asked if there was a statute number, and then didn't bother to follow up with that either by itself or through the state. And the state admittedly neglected to bring that to the court's attention, but that is the statute that was an issue, because it does talk about license tag being clearly legible from a distance of 50 feet, and it has to do with the illumination of that tag. So I think that's probably perhaps secondary to the 8-133 violation. In getting ready for this argument today too, I mean, like I said, I think if you compare the state's argument to what we're talking about with, this wasn't a registration issue. This had to do with clearly about the officer's ability to do that. So, so you can't say, hey, once they found out that the tag was okay, then you had no reason to stop. That's simply not true in this case. And that was the state's whole argument below. As far as, and I go into this in my reply brief a little bit, at length during the hearing, the prosecutor went on about how the warrants made a difference in our ability to arrest Mr. Moss legally. She also threw in some stuff about reasonable suspicion regarding the drug crimes and things of that nature. But I think the main focus from the state's position is once they discovered that warrant, that attenuated any illegality. And again, we strenuously object to any finding that there was any illegality. This is my backup argument to this situation, is that once that happened, there was no absolute mandate that the evidence be suppressed, even if there was a violation. As I go through in my reply brief, there are some factors that weigh in favor of Mr. Moss, and there's some factors that weigh in favor of the state. Clearly the length of time doesn't favor the state. It happened right after the so-called violation, as the district court found. However, the state didn't act egregiously here. This warrant existed prior to the stop. The state didn't anyhow manufacture this. Both officers at that scene knew Mr. Moss. So, getting his ID, that didn't really do a whole lot as far as identifying him. He would have been he was identified already. The question became, well, can you continue to hold him to run the license check? And finally, with regard to any kind of malfeasance or wrongdoing by the police, the state would submit that the law in this area is not so clear cut that this violation would have been obvious. That's what we've been arguing about the whole time. And the fact that we have McSwain and Edgerton and Lyons cases indicate that, there are some distinctions that need to be made here. So this wasn't any kind of egregious conduct by the officers, and there's no reason why the attenuation doctrine wouldn't apply, and that the warrant, the disclosure or finding of the warrant warranted his arrest. And with that arrest, the car was sitting there and it was able to be searched with a drug dog. I'm not trying to cut that short and say this was a search incident to arrest or anything like that, because that's not what happened. But what happened after his arrest really was not an issue as the case played out.
You still have about a minute and a half left.
Okay. I know I didn't file a 609 letter. There was a case that came out, and I feel like I should tell the court because it doesn't necessarily favor me. But in all candor to the court, the State v. Shelby Ellis case that came out on August 7th, 2020. There's no can cite to it, but it's 469 P3D 65. It talks about attenuation. And I just wanted to bring that to the court's attention when they're looking and analyzing this case.
What does that case stand for?
Judge, that case essentially, it reduces the thought process or logic that the warrant washes away any illegality in a case. And it takes a hard line look, and I think it's from a 4-3 split on our Supreme Court regarding when that attenuation can apply. And it seemingly the court has taken in my mind, a fairly radical view that if there was an illegality involved prior to that, then that warrant will not absolve the state's actions and allow you to go forward. But in the state's view, that's the whole purpose of the attenuation doctrine, is to, if there's no illegality, then there's no need for the attenuation doctrine. So we think it unduly limits what's going on with the attenuation doctrine.
Thank you.
Counsel, thank you. You've used your time. Mr. Adam, you have 15 minutes.
Thank you, Judge. May it please the court. Again, Jeff Adam on behalf of Anthony Moss, and we are asking that the court affirm the court's suppression order. And I don't view this so much as a violation of 8-1706, so much as an issue as to whether or not 8-133 was violated. And I say that for a couple different reasons. The first being that there is a certain time when 8-1706 becomes applicable, and that is from sunset to sunrise, and then also when certain weather conditions would dictate that lights are necessary. And there was insufficient evidence presented at the suppression hearing as to whether or not sunset had even occurred and that lights would have been necessary. The other reason that I don't see 8-1706 coming into play here is that the state at the suppression hearing particularly kept making an issue of the fact that the light was not affixed properly, that it was swinging or appeared to be in motion. But there's actually no requirement under 8-1706 that it be fixed or stationary. Really, the issue is whether the light itself makes the plate visible from at least 50 feet. And there was no evidence presented at the suppression hearing that the light itself was defective in any way, or that it was the light that was causing the tag to be unreadable. And typically when we see 8-1706 violations, they're referred to as defective tag lamps. And that's because there's just no light illuminating the plate at all. In this case, the light worked. And if you look at Sergeant Beckman's testimony, he actually testified that the light itself wasn't the true obstruction. He viewed that the condition of the plate was the true obstruction. And so really, if the light comes into play, I think the light comes into play still under an interpretation of 8-133, and that was the light a foreign material that would have obstructed the view of the plate. And I think the condition of this plate, the testimony's inconsistent because Mr. Loudon had said that the officers assumed that the plate had gotten wet, but I don't think that that's true. That's what the testimony actually indicated. Sergeant Beckman did indicate that he felt that the plate had gotten wet and that it was shriveled up like bacon. But that wasn't Officer Tulin's testimony. Officer Tulin actually testified that he didn't recall that the plate appeared to have been wet. So I think the testimony was inconsistent on that issue. And that may have been why the court, in addition to the fact that a picture of this tag was just never presented, that the court didn't feel like there was sufficient evidence that this plate was actually illegible. And
let me ask you about that, Mr. Adam, because on review of a motion to suppress, we look at the facts to see whether or not the facts that were found by the fact finder, in this case, the district court judge, to determine whether they're supported by substantial competent evidence. And the district court judge in this case found that from 15 feet, at least, that the plate was illegible, right? And then the court went on to find, though, from 5 feet, it was legible, and therefore the reasonable suspicion dissipated. And you didn't object to that finding, right? That factual finding that it was illegible from 15 feet?
No, Your Honor.
Okay. And so would you agree that on appeal, there's substantial competent evidence in the form of the testimony of the officers to support the judge's finding in that regard?
Yes, I would agree that there is evidence from Sergeant Beckman that he wasn't able to read the plate from 15 feet. And then there was also evidence from Officer Tulin that he wasn't able to read it from a car length away.
Okay.
I would suggest, though, that that's why I think the distinction between 8-1706 and 8-133 is important, because in 8-1706, there is a requirement that the plate be legible from a specific number of feet, at least 50 feet. And that if that were in play and that were being violated, then that's not necessarily dissipated when the officer walks up and can see it from 5 feet away. But
Okay, so 833 says that the plate must be in a place and position to be clearly visible and should be maintained free from foreign materials in a condition to be clearly legible. And you're correct that it does not talk about how many feet. So we are, because the district court found as a matter of fact that it was not legible from a car length, and you're not disputing that fact, what would you have us do with interpreting this statute? What is this? How should we interpret this statute? How far should it be?
well, what I would ask the court to do is do what the courts did in McSwain and Edgerton and find that if a traffic stop is effective because the tag's not visible from, say, a car length away, then that's fine. There's justification for the stop. But once the officer is able to get out and determine that it is legible, then at that point, all the officer can do is just advise the driver of the reason for the stop and let him go on his way. Because,
Well, Mr. Adam, I read actually Edgerton and McSwain, and those were not the reasons for the stop in either one of those. The reasons for the stop in those were whether or not the registration was current. It wasn't.
Right.
It wasn't because there was a violation of 8-133. So that's completely different. So when what they were doing is the reasonable suspicion for the stop in those two cases was, gee, I think they're violating the statute that says you have to have a current registration. And so they went up, licked it off. Current registration, therefore reasonable suspicion dissipated. It's dark outside. I don't believe there's, they might be violating a current registration. Get close, dissipated. This is completely different. This is, I think there's a violation of 8-133. You can't see this from one car length away. So yes, you get up, and from 5 feet away, you can see it, but it doesn't dissipate, right? Because still, even after you're 5 feet away, you still can't see it from a car length away. You see what I'm saying?
I do. What I took away from the cases, though, is that the reason that they felt that there may be a registration violation was just because they were not able to see the tag. And that's what I think is similar, if not identical, to this case. Is the issue here is you don't know if Mr. Moss has a current registration or not because you can't read the tag.
So you didn't think that Lyons distinguished those two cases based on that reason?
I thought the distinction between Lyons and McSwain and Edgerton is that in Lyons, there actually was a foreign material. It was salty and dirty that required physical manipulation for the officer to be able to view whether it was a valid tag or not. And in Edgerton and McSwain, there was no requirement for physical manipulation. The officer just had to get close enough to the vehicles. And that's what happened here is once Officer Tulin was close enough, he was able to read it. He didn't have to remove any dirt or move this light that seemed to be something they took issue with.
Well, I forgot what was the reason they pulled him? What was the reasonable suspicion in Lyons? Was that the one with the tire underneath?
Yes.
Okay. And was there tape over the?
No, the tape was at an issue, I believe,
Okay.
in McSwain or Edgerton.
Okay. What was the reasonable suspicion in Lyons? Do you remember? I can't remember. So if you can't remember,
What I do remember is that he was positioned in a way.
Right. That's the part I remember.
In the median that when the car went up a hill, he could see under the vehicle. Somehow.
Right.
But
Yeah.
What I took away from it was that he didn't necessarily believe that was enough. And that's why, like in this case, he came up with a traffic infraction to actually affect the stop.
Okay.
And I guess with my remaining time, I would just address the attenuation, like Mr. Loudon conceded. I think when you consider the temporal proximity, that's certainly in favor of Mr. Moss. And then when you go to determining the purpose or flagrancy, what I would point out in this case is that Officer Tulin didn't just innocently come across this warrant while he was effecting just a regular traffic stop. They were actually out there with an intention of surveilling what they believed to be a drug house. They suspected or thought that this particular vehicle that Mr. Moss was driving might be engaged in drug activity, but they admitted that, or at least Sergeant Beckman admitted that they didn't have reasonable suspicion of drug activity to be able to pull over the vehicle. They needed to come up with or manufacture a reason to pull the vehicle over, and that's
Pretext. Yeah, it was definitely a pretextual stop.
so. I think that certainly weighs in
But of
favor.
course, our United States Supreme Court allows pretextual stops.
Sure. Well, and like the district court noted, pretextual stops are constitutional, but you've got to be very clear in establishing that there's actually a traffic infraction.
Right.
Your Honors, I don't know that I have any additional comments unless there are other questions from the court.
No, thank you.
See no more questions. Thank you, counsel. Mr. Loudon, you have 3 minutes.
Thank you, Your Honor. To a large part, I agree with Mr. Adams' comments about 8-1706. Again, I think that was just required for some context regarding why the testimony was the 50 feet. And I think I did concede that, this was more about 18 or 8-133. So I don't really have a lot of, take a lot of fault with anything that he had to say regarding that. He did talk about insufficient evidence, and we're not to that point yet. And I think 8-133 should be the focus for this court, but that just gives some context to why the testimony was the way it was. Regarding the wet plate, again, I think that's a red herring. That was just by explanation. There was no indication that the officers disagreed on the condition of the tag. The condition of the tag was it was shriveled up or wavy or something, that to the point that, like a piece of bacon, that it couldn't be viewed. I would also note, and I have this issue with some of these traffic stop cases where we talk about the dissipation of the reason for the stop. We're not talking about a beyond a reasonable doubt standard here. We're talking about, was there a reasonable suspicion? And, I think a lot of the comments often go off to, well, could we have proven this beyond a reasonable doubt or something of that tenor, whether it's express or implied? But we don't have to do that at this point in time. We're doing an investigation. The officers are doing an investigation, and they're trying to do this by the book. And I don't see anything out of line with regard to what the officers did in this case. Just by way of comparison, perhaps, we have statutes that talk about, there's other statutes that talk about license plate coverings and the visibility of the license plate. And this is essentially the essence of our argument, is this wasn't a registration case. This was about being able to see that tag. And I don't think we ever departed from that. And I don't think that ever dissipated in this case. Oh, I didn't write the initial brief, and I know this court is busy. I don't agree with, I hate to say this, but I don't agree with our prosecutor's take and emphasis on the drug stuff and the totality of the circumstances. I think this is a plain and simple, was this traffic stop validated? I think some of that other talk about the totality would be important if this wasn't a warrant case. But I don't see how that any of that supposition regarding the drug crimes factors into this court's decision regarding the validity of the district court's decision. Because I don't think she even went there. I think she kept it where she should have kept it regarding traffic violations and was there attenuation. I don't see how the drug stuff really factors in, especially since we can have a pretextual stop.
Mr. Loudon, thank you very much. Dave, I have to say it's a little strange to see you appearing on behalf of Riley County. I'm used to you appearing on behalf of Sedgwick County. So,
yeah, it's been a while too.
I hope the new job's working out okay. Counsel, thank you very much. We appreciate your arguments. We obviously will take this case under advisement, and we'll try to get a written opinion out to you as soon as possible.
Thank you very much.
Thank you for your argument.